Well, let's get going for this evening. And for those of you who are new, I'm going to run through just a quick high level, and then we're going to dive right into it because I think we're going to keep these ladies hopping today. There we go. Okay, so my name is Elizabeth Kelly, and I'm really excited to welcome all of you here to our webinar this evening, Preventing Legal Issues Before They Happen, because that is the easiest way to deal with legal issues, is to plan, prepare, and then do our best to prevent them, because it's super expensive when we try and deal with them after they've already happened. So we have Milena Cardinal from Cardinal Law here with us. Milena is a real estate lawyer. And we have Shaneka Shaw-Taylor here with Tailored Litigation, which, congratulations, Shaneka just opened her very own boutique law firm. So excited for you. And Shaneka specializes in litigation. So we've got kind of the two most common elements of legal issues that we face in the real estate world. I mean, there's other ones like tax and those kinds of things, but we're going to focus on the most common ones this evening. And I'm so excited to have both of these stellar ladies here to join us and share their knowledge and expertise.
Thank you so much for having us.
Oh, my pleasure. My pleasure. And we're very lucky because I know, Milena, you've had a long and busy day, and Shaneka is juggling the new business and the baby and all those other fun things. So really appreciate you taking the time to join us this evening. And of course, appreciate everyone attending, because I know it's gorgeous out, and you could be sitting outside by the pool. Maybe some of you are, in which case I'm very jealous. Just just a quick reminder, anytime we're talking about real estate, always make sure before you take action, you're doing all of your own research. And this includes, but is not limited to, talking to others about their experiences and making sure you surround yourself with amazing people on your legal and accounting teams, and that you're doing your proper due diligence before you move forward. So I do not endorse any particular attendee, participant, speaker, investment, sponsor, advertisement, or anything else presented during these meetings. And all the expertise that I share with you is from my own almost 20 years of experience as a real estate investor. And that's why I like to bring on pros like Milena and Shaneka, who can provide really high quality information for you as well. Just a quick orientation again on Zoom. So if you are new to the webinar format, on the right-hand side, you will be able to see in the chat box, you will have a choice here. There is typically hosts and panelists, and there is a drop down that you can click to change it to everyone. This allows you to engage with everyone in the chat. Please, in the chat box, click the drop down, choose everyone, and then you're sharing great information with everybody. If you have a question, please use the Q&A tab, and you'll be able to see it. It looks like this right here. If you have a question, use the Q&A tab, because the chat box can move really quickly, and then your question can get lost in the shuffle. So please use the Q&A tab. We do have time. I have built in a ton of time into this webinar to be able to ask for people to be able to ask their questions and get them answered by the ladies, because we know it's super expensive, and we love you guys, you're experts, but sometimes we just have a quick one and we just need a quick answer. And that's why we appreciate so much your time this evening. So our agenda, quick introductions. We're going to do a panel discussion. I have 4 major questions to get us started, get everybody warmed up for the evening. And then we're going to dive into the questions from our audience. And I'll be back at the end to do a quick webinar wrap up. As always, I'm your host, Elizabeth Kelly. I am a coach and a real estate investor of almost 20 years. I am currently spending a lot of time helping people navigate the challenges and pitfalls that we are encountering right now with the higher interest rates. If you are struggling, if you have negative cash flow, if you're not sure what to do, by all means, reach out, book a discovery call with me. I would love to help you figure out a solution to the challenges that you are currently facing. I have a whole bunch of tools in my tool belt, and I'm more than willing to spend time helping you navigate the current market. I always get provided with bios for people, but I really just love to talk about why I have guests on in my world. So Milena and I have been friends for a number of years now. Milena is my go-to lawyer for so many different things, but I think my favorite thing is I got really tired of hearing from lawyers, well, you can't do that. You can't do that. Or I'd go to them with a closing and then they'd be like, well, I don't recommend this. It's not a good business move. And that gets really old. So I love Milena's response, which is typically, you know what? I can't see a way to make that happen yet, but give me 48 hours. Let me think about it. And I'm going to come back to you and I'm going to have figured it out. And you know what? She does. And I love that. I love that kind of creativity. I love that kind of out of the box thinking. And I love not getting advice that isn't applicable. Do you know what I mean? Does that make sense? Which isn't to say that Milena isn't fantastic at running her own business, but she is. But I come to my lawyers because I'm looking for that legal help, for that legal advice. And I love it when I can get a solid answer that is, yes, this is legal, or no, that isn't legal, but let's try this as an alternative. I love that creativity. And then And then just a few months ago, Milena introduced me to Shaneka, and I have absolutely enjoyed getting to know Shaneka better. She's working with a couple of my clients, and I say unfortunately, not because she's not doing an amazing job, but she is, but because I do have a couple of clients who are in a couple of litigation situations. And it's funny because I have been sued in the past. It happens to all of us, whether it's, slip and falls and it goes through insurance or whatever the situation may be. It might be a disagreement with a partner. But one of the things I look for in a good litigation lawyer is sort of that, iron fist in the velvet glove. And that is Shaneka. She is like the soft, smooth, quiet until you need the big guns, and she's got them. So Shaneka, I'm so glad to be able to add you to my power team and to include you in my network of trusted advisors.
Happy to be here.
Wonderful. All right. So the 4 questions that we are going to start with this evening. How do I know when to incorporate? Because this gets asked. This is like investing 101, the basics. So we'll talk quickly about how to know when to incorporate. How do I protect myself from lawsuits? What are the essential components of a joint venture agreement? And then we're going to really warm things up, and we're going to ask for some real life examples of mistakes that investors have made that create major liability or lawsuit risks. Sound good? You ladies ready? Everybody else ready? Where's my chat box here? Where's my chat box? Oh, Teresa has to go. Looking forward to the recording. Absolutely. There will be a recording sent out usually by Friday. Mary Beth, my wonderful assistant, is able to get everything edited and send out the recording. So if you're registered, you will automatically receive a copy of it. You don't have to worry. Oh, good. Everybody's saying, let's go. Okay. All right. Milena, why don't we get you to kick off? How do I know I'm a new investor? How do I know when I should incorporate?
Well, you start with the easy question. It's actually a really complex question because I wish I had a one-size-fits-all answer. And unfortunately, the answer is, as us lawyers usually say, it depends. There are so many different factors that go into play to decide if someone is ready to incorporate. There are 6 main categories of factors that I've determined to be the different areas that I look at when I'm looking at whether someone should not just incorporate, but what is the ideal structure for them, right? We're not only looking at necessarily incorporating, but even someone who may have maybe 3 or 4 corporations. How does this new deal fit within that structure? Or am I ready for a family trust? That's a big one I get. So whenever we're talking about corporate structures as a whole, what I'm looking at is the 6 items I'm looking at is taxes. So that's a big one. Liability protection, of course, is like a key element that people look at. Financeability. So that often gets overlooked by lawyers and accountants I've seen. And I've seen people like newbie investors, if for instance, incorporating a structure involving a family trust. And that makes them virtually unfinanceable. If you have a family trust in your structure and you're a brand new investor, or you have less than 50 properties, you have to be at a point where you have so many properties that the bank is salivating at the mouth at lending to you. Otherwise, a family trust blocks you from banks, period. And so what a lot of newbie investors do is they get recommended to do this family trust, which is a good tool for the right person at the right time. And then they do this family trust, and then they buy properties outside of their structure because they can't make it work otherwise. So financeability is a big one. So I said taxes, liability, financeability, attractiveness to investors. So one of the elements that, and I actually discussed this today with a client, was the fact that this is a new investor, but he's got massive goals, right? Major goals, and he's going all in, and he's put in everything he's got into this project, and he's very ambitious, good head on his shoulders. And I'm like, you know what? I think you need to incorporate faster than anybody else because you're very ambitious, and your first project is going to require you to get investors. It's going to give you some credibility to be incorporated. If you go to an investor and you say, I want to buy this like 50-plex, but no, I'm not incorporated, that doesn't look great. So that's a factor too, attractiveness to investors. Life goals, right? So you may look at an investor that maybe a smaller investor that's never incorporated, but now they're looking at passing their portfolio to the next generation. Maybe it's time. Maybe then it's time to incorporate, even if they weren't, it wouldn't be. And then lastly, the last element is cost. So always looking at cost and making sure that we're not setting people up for failure by encouraging them to get a structure that may be the very best structure for them, but going to cost so much that then they don't even have their down payment anymore. So to recap, taxes, liability, financeability, attractiveness to investors, life goals, and cost. And all these factors come into play in the puzzle of determining the ideal structure. And the answer usually comes from collaborating with the power team. So I don't come up with the answers on my own, or very rarely, unless it's extremely clear cut, which is rare. Most of the time I'll be partnering with your real estate coach, with your accountant, with your mortgage broker, with anyone in your power team that can give advice depending on where you are in your journey.
Yeah, I love that. That was such a fantastic answer. And it really highlights why you are such a great choice as a lawyer, because you anticipate what those needs, what a client's needs would be, and you're already prepared to be able to answer them. It is so frustrating. You're working with a new lawyer and you ask them a question, they tell you, well, that depends. And they go, you have to talk to this person, this person, this person, this person. And you walk away and you have all these different opinions and you have no clear-cut answers, and you're no farther ahead than when you started the process weeks ago, because that's how long it takes you to talk to all the people. I love the idea of being able to get everybody together in one room, hammer out the solution, and let's just make it happen. That's fantastic. Thank you. Shaneka, did you have anything you wanted to add to that? Or are you okay if we jump to another very broad question that is right up your alley?
I think Milena covered it perfectly. Having the right investor-focused lawyer is key to making sure that you're doing things properly.
Absolutely. Absolutely. So the second question, how do I protect myself from lawsuits? What are some of the top 3 things I can do to minimize the likelihood that I'm going to get sued?
So I would say it would be 3.5 things. And I'll start with the half thing first. And the half thing first is slow down. Particularly as newbie investors, we get excited, we just want to get our properties under our belt. We want to get going as quickly as possible. And we tend to rush through the process, right? Rush through the process in terms of signing too quickly, not reviewing our documents, just going too fast. So slow down. Slow down. And then the second thing I'd say is make sure you have your contracts prepared by investor-focused realtor, and have them reviewed by investor-focused lawyer like Milena, right? Because you want to make sure that you're thinking through the various risks, and you also want to think about what are the goals I want to accomplish, and do I have the right terms and provisions in my contracts and my agreements to cover those risks, to cover those goals? Does my contract limit me from liability exposure? Do I have the sufficient provisions in there to protect me from that? Does my contract talk about how I recover losses if I'm ever, I found myself in a situation that I don't want to be, I don't anticipate? Are there certain steps that I need to take before this agreement goes firm? or after the agreement goes firm. So making sure that the contracts are drafted and reviewed by an investor-focused lawyer. And when you're getting into buying a property, I always tell my clients, particularly when I brought in earlier rather than later, and it tends to be later that I brought in, but always make sure you have conditions in your agreements of purchase and sale. Even if it's throw all lawyers review or due diligence, that is, my friend, the top way to protect yourself from lawsuits. And we'll talk about it a bit later about some of the big lawsuits that I'm seeing now, but a lot of them can be avoided by making sure your contracts are conditional as much as you can, and particularly in this market where it's not really a seller's market and they're not huge bidding wars. You have time on your side more so than a year ago. So if you can put conditions in your contracts, I highly, highly recommend you do so. So that's the first one. Have your contracts drafted and reviewed by investor-focused realtors and lawyers. The second way to protect yourself, I'd say, is get insurance in place, right? You don't want to have a trip and fall or an incident on your property and that bankrolls you, right? You want to make sure that you have the different insurance policies in place. Get a good insurance broker. Get a good insurance broker and communicate to that person what it is that you're trying to accomplish. Just like Milena talked about the power team, you want to make sure that your power teams includes a good insurance broker. Because you can go out and get, let's say, fire insurance or a general insurance that you think protects you and your property, but because you haven't either read the insurance policy or understood the insurance policy or discussed it with your broker, you may not be on the same page as to what exactly am I insured for. And then when stuff does happen and you review the insurance policy and the insurance company is like, sorry, that's not covered. And you're like, but I've been paying premiums for years. What do you mean that's not covered? And I see that quite a bit. And then, part of what I do is insurance coverage work. And that can be expensive when you're trying to go after an insurance company for something that you think should have been covered. But in the contract, if you read the policy, they have all these exclusions. Right? So make sure that you're talking to your insurance broker, explaining to them what you're trying to accomplish and protecting yourself from that way. There are so many different types of insurance policies out there. Fire, business interruption, title, just making sure that you're covered from all angles as much as possible to protect yourself in the event that something goes wrong. And the third thing I'd say, and this is perhaps just as important as the other two, is making sure you're doing thorough due diligence. Thorough due diligence, vetting your tenants, vetting your service providers as best as you can. I'm talking about your property managers, contractors, everyone on your power team, vet them as thoroughly as you can, particularly service providers, making sure you're looking into what's their track record. Can I talk to some of your clients to see how you've done in the past? How have you handled situations that haven't gone so well, right? Is your contract with that service provider covering you for instances where things may go wrong? I always tell my clients that, they go into this relationship of investing in real estate and we have these rose-tinted glasses on and we only see the good things, right? Oh, I'm going to make cash flow every month. This is going to be great. But they never stop to think of, well, what could go wrong? Not that it will go wrong, but what could go wrong? And how do I protect myself from things that go bad? So that's making sure your contracts, as I said before, are ironclad as much as possible. And that sometimes means taking a step back and thinking about what are the potential risks here and how do I protect myself? And that's with service providers in as much as it is with a seller or a buyer. So those are the three big buckets.
Those are amazing. I love those. You guys, those are fantastic answers. One of the biggest things that I've learned as a real estate investor is just because you're right doesn't mean you're going to win. And it doesn't mean that it's not going to cost you money. So I had a lawsuit, for example, it was just settled, I guess about 4 weeks ago. And we had, I had a property management company. For those of you who are new to my community, for 15 years, I was a property manager in Northern Ontario. I had property management contracts, just like Shaneka said. I had an owner who signed a contract, agreed to have work done. We performed the work, and then he suddenly changed his mind and decided he didn't like the rates that were written right into the contract, refused to pay. That's it, ghosted, just disappeared. So it was an insurance claim. And he had said, help me float this. And, when I get the money, I'll pay you. Well, he got the money and he used it to upgrade apartments and never paid us. So we liened his property. So in the end, he signed the contract. The contracts were good. He agreed to everything. We did everything we could. We still had to sue him when we still only got 55% of the money that we should have gotten. And we didn't do anything wrong. So that just goes to show you how important it is that you set yourself up for success by making sure you're not doing anything wrong. Because if we had done something wrong, if we didn't have the documentation, if we didn't have the emails, if we didn't have the contract, I don't think we would have even gotten that. Yeah. So,
and if I could add to that, something that I just came to mind is, so one of the things that I always tell my clients when I'm in a consultation or just in the beginning stages of the relationship is, yes, you may be right. Yes, we can start a lawsuit. Yes, you may win. But winning really means I can get you a piece of paper that tells you that you're right. That doesn't mean I'm going to get you the money that you're after. It doesn't mean I'm going to get you the house that you're after, right? I'm going to get you a piece of paper that says you're right. What will happen with that piece of paper afterwards is anybody's guess. So what we do at the beginning of the lawsuit is asset searches. If I take this to court and I win and I get my piece of paper, how can I recover on this judgment? So we typically, in our firm, do searches on the other side. Do they own assets? Do they have a job? Is there something that if we win, we can claim on to recover any money that we've lost? And that's not to say that things may not change over time, but at least you have some assurance going into a lawsuit that, okay, if I get a judgment for 10,000, 100,000, whatever the amount is, maybe I can garnish their wages, I can sell a property that they own and recover the amount that's owing to me, rather than paying us thousands of dollars and yes, getting a piece of paper, but never be able to actualize that piece of paper.
Yeah. That's such a great point. I love that too. Wow, we could spend hours. Okay, so next question. The essential components of a joint venture agreement. Milena, why don't we start with you and have you lay out the foundation, and then we're going to have Shaneka lay in the goodies that she likes to see on top of it based on the lawsuits that she's seeing.
Well, and I love that this is the question that you're asking, because I'm actually going to take this opportunity to answer Mohammed's second question, which is that are there anywhere that he can get a template of a joint venture agreement? Please don't do this. Please don't. Friends don't let friends draft their own contracts. Please don't draft your own contracts. This is how you attract liability. So, so to answer the essential components of a joint venture agreement, there's actually a lot that goes into it. And some of it may seem standard, right? And they tend to just follow from agreement to agreement. And they're kind of like the boring legalese stuff that people don't pay too much attention to. And then when there's a problem, you're really happy when it's drafted properly. So, so a few elements that will be on there, for instance, the parties, right? So who are the parties to the contract? And that's actually a more complex question sometimes in some contracts than we would think. For instance, it's obvious if you've got a qualifier, a financer, and a manager, right? Like those are the typical parties you can imagine. But sometimes you don't have all your financiers lined up. And so now you're talking about adding a party to an agreement later that's going to finance something else later. And then you've got to document that. And how do you incorporate that person or that party to the agreement without them actually being a party yet? So it's really important to define who are the parties to the agreement, who are bound by the agreement. Who does what is typically set out. That's a pretty basic one. The percentage of ownership. The percentage of ownership, not only of the property, but of the other assets of the joint venture, which could be things like the bank account or, I don't know, appliances that you're furnishing with the units, whatever, right? But also the insurance policies. Really important to determine how the insurance policies are owned and what happens if there's a loss, how the proceeds are distributed, because it is very likely that the insurance is going to be in the name of whoever is on title to the property. Which takes me to the next element. It's the trust relationship. The trust relationship has to be properly documented in the joint venture agreement, determining that whoever is on title is holding the property in trust for the various parties in the joint venture agreement. So for instance, if you've got a qualifier that owns 10% of the property and they are on title to the property, and then you've got, say, the financer that owns 50% and the manager that owns 40%, well, the qualifier only owns a small percentage, 10%, but they're on title to the property. So we've got to make sure that that trust relationship is properly documented to say, yes, I am on title, but I hold it in trust for the other partners as well. And the other element that will be also included is whether or not the joint venture wishes to permit the registration of something on title, determining or protecting the parties from that, from the qualifier or the person on title being able to sell the property from under the other investors. So there's different ways that you can secure that. I could get into it and talk about it forever, but suffice it to say, there's different ways that you can secure it. That's where a good lawyer comes in, because they can give you the options and you can see as a team what works. Otherwise, the authority to act has to be really well laid out. So usually again, there's not always a usually, but typically with my clients, I recommend having what we call a financial manager, which is usually an individual that is named. And even if all of the parties are corporations, then that individual is given authority to act on behalf of the joint venture and do certain things. It could be as high as making all of the expenses, making all of the decisions, hiring the property manager, all without the permission of the others, or it could be really restricted and say that person needs to check in on a monthly basis or on a weekly basis with the team, and they are very limited as to what decisions they can make without the permission of all the partners or of a majority, right? That's also an element that comes into it. The what happens if clauses need to be in there. What happens if somebody dies? What happens if someone's disabled? What happens if someone goes to prison? What happens if they become a missing person? What happens, because another element to all this is that your partner is only your partner until they pass away or they become incapacitated. Then your partner is the power of attorney or the executor of that person. So if you don't want that spouse to be your partner, that needs to be decided ahead of time, and it needs to be determined who's going to be named as the attorney under power of attorney for this project, to make decisions on your behalf if something happens to you. And how to get the F out clauses is the other ones that are super important. What happens if someone wants out, right? Can they get out? Is there a penalty for getting out? So termination, buyout, what happens if nobody can agree and the project stalls? This is all things that need to be ironed out in minute detail. It's really important. Friends don't let friends draft their own contracts.
I would add to that what if list. Usually, what I come across at least is, what if one of the partners is no longer doing what they said they were going to do?
Yes.
Right? That's usually the big thing that people tend not to think through. And I like to see written down in paper what will happen. So what will happen if the managing partner is not managing to a certain threshold? What happens if the financing partner can no longer, honor its financial obligations? Because when you don't have that level of detail, then it comes to me to try to figure out, okay, how do we extricate you out of this? Or how do we fix this situation? And if you don't have your intentions clear on paper, then, you know, how is a judge going to decide what's in the best interest of the parties, right? You want it to be as clean cut and as clear as possible, so that if it ever comes to a litigation lawyer, it's just right on paper, right? It's not for us to go to a judge and try to convince the judge, okay, Your Honor, this is the path that you should take. Because quite frankly, the court system is backed up. Judges have a lot on their plate. They're looking for the path of least resistance, right? So if you're coming to them with your dispute and asking them to try to navigate this dispute, the easiest thing for them to do is to say, you know what, I'm wiping my hands of this, sell the property, and everybody just takes what is they're entitled to and carry on. And that brings me to the other point is you want to be able to, in your joint venture agreement, talk about what happens to the property in the event that one or two parties wants out. There's a legislation that we have called the Partition Act in Ontario. And essentially what the Partition Act says is co-owners of a property have a presumptive right to have that property sold if they want out of that property, right? So you may have spent thousands of dollars putting together this beautiful joint venture agreement. You know, you run this property for a few months, a few years, few days, and then somebody decides, I don't want a part of this anymore. Unless you specify in your contract what happens, particularly with the Partition Act, and you can contract out of it, but unless you specify in your agreement and be clear what happens in those situations, then you may end up, you know, in a position that you don't want to be in. So these are the things that, again, to Milena's point, you don't know unless you're in the trenches doing it, and precedent joint venture agreement offline won't think through these things for you. So it's really important to get the right legal representation.
I actually have a question for you, Shaneka. I spend hours of my time dissecting through definitions and interpretation clauses. Again, stuff that nobody looks at, right? And it's like sometimes I have to, when I'm reviewing a contract from another lawyer, I have to be to my client, be like, their words in the document, it's not clear which ones are defined and which ones are not because they're not capitalized. And I know it sounds dumb, but it's so, in my mind, it's so important. So my question to you is, has this come up in litigation, like interpretation of specific words? Like, have you experienced any of that?
Oh, absolutely, all the time. And the way my brain works as a litigator is if I have a 50-page document, my job is to convince the court of the side that I want to convince them. I have to share and sell a story. And I have to share and sell a story in as simple a way as possible. So if I have a 50-page agreement that doesn't have the appropriate headings, doesn't have, you know, the style and language that a court can readily and easily understand, including italics or capitalization, the things that as lawyers we're trained to look for, it makes my job harder and it makes the job of the court harder. I don't know if you guys have heard of the multi-million-dollar comma. So there's this case, I think it's in the UK or the US, where there is a comma was inserted in a contract, and the whole interpretation of the case, multi-million-dollar case, turned on the words that followed that comma and what it meant to the actual provision that was at issue. So it's super important, and I can't stress this enough, to have your documents reviewed and drafted by lawyers, because you may think as a lay person, okay, this sentence makes sense. But as lawyers, we dissect every word and every term, and depends on what side you're on, we make that sentence or term, you know, fit the way we want it to fit. So, yeah.
But I think one of our teenagers has a T-shirt that says, "Let's eat, comma, grandma. Let's eat, grandma. Grammar matters."
It so does, right? And I find that it's a lost art, right? It really is a lost art.
Yeah, absolutely. Inconsistencies too, by the way, I wanted to bring up. Oftentimes in self put together contracts, I find inconsistencies, and that can be extremely dangerous because one person can interpret it one way and another a different way.
Yeah, I agree. And I would like to add in something, not obviously from a legal perspective, but I think we're making a lot of mistakes. I see it happen a lot. All I saw was stop clubbing baby seals. Sorry, it came up in the chat box. I think a lot of us are doing things a little bit backwards. So we find the deal and then we're out there and we're scrambling, we're looking around for JV partners. And then we're like, hey, can anybody qualify for a mortgage? You know, has anybody got the down payment? And then it becomes, okay, this person. And then it's like dating, you know, it's like making a commitment to someone before you've decided if they're an actual partner. It's like 90 Day Fiancé, really. I mean, I've never watched the show, but it's what I imagine it's like, where it's like, okay, well, you can qualify for the mortgage and, you know, you have the down payment, so you must be a great partner. And I believe there should be a whole conversation around, you know, what are the components, you know, who is going to be responsible for what, who's going to be on title, what is it going to look like, you know, when are we meeting, you know, what does the reporting look like, who's responsible? Like, those are really critical conversations that should be happening in order to draft the JV agreement. And the agreement should really be solidification of conversations you've already had. But a lot of times people, like you, to your point earlier, Shaneka, people are rushing. They're literally like, I've got 30 days for financing. I got to put this all together. And they're literally getting married to people that they know virtually nothing about. They don't know their ethics. They don't know their integrity. They don't know their experience. And this is where I'm seeing there be issues with, like, well, this person looked like they had their, you know, stuff together when I saw them on Facebook. So how come this isn't working out? I think that's a big learning, and we have the opportunity now with the way the market is, but let's slow it down and let's really spend time getting to know who we want our partners to be. And let's find the partners before we find the deals.
Absolutely.
You know, let's dance before we get married, so to speak. Yeah. All right.
He totally made my argument for a prenup in there too.
I think, you know, that's all. You just reminded me too. And it doesn't matter, you know, if this person who's your JV partner, if they're a friend, if they're a family member, you still need an agreement. Don't make the mistake of thinking that because, you know, this happened or that happened. My husband's best friend passed away unexpectedly at 36. My husband and he owned 8 properties together, and we got really lucky that his widow was very reasonable and relatively easy to deal with, because it could have turned into a complete and total nightmare. They had no documentation. They had nothing in writing. There was just nothing. They were best friends. They just did everything together. So make sure, no matter who your partner is, that you have an agreement. And please, please, please make sure you have a will and a power of care and a power of attorney in place. Like, you should have this anyways. As soon as you hit like 20 years old, you should have all those. But especially when you start buying properties, please protect yourself and help. You know, when people are grieving, they do crazy, crazy things. So make sure that your wishes and your who's going to be responsible for decision making is clearly understood right from the very beginning.
Yeah. And even if you think, oh, it's a family member, I trust this person, get it documented. And if you are afraid that it's going to come across negatively or, you know, not received well, you know, you can always say, you know, I'm doing this to protect you. It's not me. I'm doing this to protect you, because you wouldn't believe what could happen. People change. People change. I had a client who I wrapped up a lawsuit for. Took us over 3 years, a lot of money. And what happened is he bought an investment property. And because he wasn't in the country at the time that he bought it, he decided or thought it would be good to have his sister on title with him. She can move into the property, help him cover the cost of it, rent out the rest of the property to help carry it. 8 years later, she decided, well, I'm on title, so I'm half owner. Right? And yep, and nothing was documented because it's family. I trust them. And yep, she ended up, much to the chagrin of my client and, you know, the family, walking away with almost half the kitty, right? All because they trusted each other And not to say you shouldn't trust your family or your friends or your partners, but it would have been so much easier and cheaper for him and everyone involved if they just got it documented in writing.
Mm-hmm.
Yeah.
And
it's like that good fences make good neighbors, right?
Exactly. And it forces you to have the difficult conversations when you're in the honeymoon phase. Like there's a reason why that's the time to have the conversations. Everybody's happy, everybody's excited about the project. It's like, you know, then you can discuss how often you meet and who's doing what and what's the limit on the decision making and all that stuff. It's easy then. It is really hard to discuss these things when you're fighting.
Yeah.
Right?
100%. All right. So last conversation before we dive into the Q&A box, which is rapidly increasing. Some real life examples of mistakes investors have made that created major liability or lawsuit risks and issues for them. Milena, you're laughing so hard. What's going on over there? Do you want to kick this one off then?
Sure. I've got a few. I think one big mistake that I've seen people make is not understanding title search date and how that works. So what is called the requisition date or title search date and how the liability passes to the buyer on that date. So you don't become liable for the property on closing, you become liable for the property on the title search date. So oftentimes people think it's just boring lawyer stuff and they don't really understand it. But the purchaser's lawyer has until the title search date to do a search and to verify title. And after that date, you can't requisition any changes. You can't ask the seller to fix any issues that exist on the property. You're absorbing all the issues that come with the property if you haven't brought them up before that date. So a lot of title issues that we've had came from that the buyer was stuck with, came from not understanding that and us getting the documents too late. So, or there is, so especially with real estate investors, right? You get extension after extension after extension because that's just how it goes, but you forget to change the title search date as you're changing your closing date. And then the title search date like is months before, and then your closing date is in 2 weeks. And then I get the documents. And then I'm like, I mean, I can beg the other lawyer, but they're just going to say no. Why would they? Why would the other lawyer say yes to changing the date? So if you're lucky, the realtor for the seller doesn't really understand this stuff and is going to say yes because they're going to think it's boring lawyer stuff. But that's if you're lucky, right? So I'm joking about it, but seriously, guys, it's like a really big one that you need to fully understand and keep an eye on. In my opinion, it's more important. It's the most important date in the contract. And then another one that I see often is final walkthroughs, like not doing final walkthroughs and then finding issues after closing. These are usually more annoying issues than costly issues, but you never know. They could be quite costly. But doing the final walkthrough, and even as a seller, right? If your buyer doesn't do a final walkthrough, then you end up with like all of the stuff that they bring up after. But if they do their final walkthrough and they try to bring up stuff after, you're like, well, you did an inspection, you did the final walkthrough, like what more do you want from me, right? It's easier to say, hey, look, it's not my problem at this point. Like you had plenty of opportunity to do due diligence. So final walkthroughs are quite important. And then I want to talk about OPM, but maybe I'll let Shaneka go before I go speak about OPM.
Yeah, so with my practice, it definitely ebbs and flows with what's going on in the market. So right now, a lot of my work is mortgage enforcement work, and real estate deals gone bad because of what I said at the very beginning, people going too fast, right? I can't think of a reason why people won't put conditions in your contract in this market. You have enough time. It doesn't matter. You have enough time, right? So what I'm seeing a lot of people doing is making the mistake of going in firm without doing the proper due diligence, without ensuring that they have the financing in place. I can't tell you how many calls I get a week where people say, oh, but my mortgage broker told me, or my mortgage agent told me that no problem. Sorry, my real estate agent told me I'm going to get the financing. Don't worry about it. And they sign these agreements unconditional, and then find out, oh, you can't qualify for the financing. And I can't find anybody to come on title with me. And I can't find anybody to assign this agreement to. So there's absolutely no reason that I can think of in this market why you should be going in firm on a property unless you have the cash and you're going to buy this property cash. That's the only way, right? Mm-hmm. So that's one of the big things I'm seeing right now. And then the other thing is people not being conservative enough with their numbers when they're going into these investment properties and not having enough margin in for increased expenses, like rate hikes that are increasing your mortgages, and you haven't had enough buffer in your numbers. So now, and then we're talking about the OPM, right? You've deployed the OPM strategy, and now your margins are thin. You're begging Peter to pay Paul because you just don't have the money, and the sources of getting that secondary money to cover the money that you over here isn't coming through, right? And what I'm seeing is lenders are not renewing on their loans. They're pulling their funds. So that means, well, what happens in this case, right? If you can't repay them and if you can't find another lender to buy them out, then you're left with a situation where your property is potentially going to be repossessed and sold. And I can talk at ends about the whole, repossession and notice of sale and what that looks like, but it really boils down to not being conservative enough on the numbers, and you end up in a situation where you're tight on funds and you can't honor your financial obligations.
And remember that when the market is nervous, your investors are nervous, right? So they won't renew. They want to pull their cash. They want to, yeah.
And I think you brought up a good point there too, that communication is really important. If there's something going on in your world, if you are a borrower and there's something going on that you can't honor the commitment that's made, the best thing you can do is reach out immediately to your lender and bring them up to speed on what's going on and ask them what it's going to take to make them comfortable. Because a lot of legal issues that I've seen could be avoided just with better communication, instead of hiding, instead of waiting until the lender comes knocking at the door. Be proactive, reach out, say, hey, this is the situation, like what can we do, what are the options here, how can we work through this together, because I want to make you whole. I'm not somebody who's trying to run away with your money.
Absolutely. Absolutely.
Yeah. Okay, so Milena, do you think we can talk OPM in like 4 minutes so that we can get to the questions? That's your challenge. OPM in 4 minutes. And you probably should explain OPM just in case anybody here doesn't know what it is.
So OPM is other people's money. So that's when you need investors, private lenders, qualifying, financing partners in JVs, LPs in your GPLP structures, whatever, that's all OPM, right? Promissory note lenders, even those, that's all other people's money. So I think the majority of the mistakes I've seen real estate investors in particular make is how they treat OPM, how they treat other people's money. So one, not understanding security. So I have seen many times people borrow on a promissory note or loan agreement, same thing, by the way, loan agreement, promissory note, same thing. If I see people borrow on a promissory note, on the promissory note, it says that the loan is registerable as a lien on a property in the event of default, and that property is owned by other investors. So say you're in a JV agreement, you own 40% of the project, the investors own 60%. You can't go and give that as security on another loan unless you have the permission of your investors and you're borrowing for the joint venture agreement and it's something you guys have agreed to. That's fine, and put that in writing that you have that agreement. Because most of the time it's not that, they're borrowing for another project, but then they're like, oh, there's equity in this one, so they put that as security, thinking that'll be fine, I'll pay it off, it'll never be a problem because I'll never default. Well, until the interest rates hike, right? So that is where you have to be extremely knowledgeable about security, because technically that's fraud. That's fraud. You can't give security for something that does not belong to you. You can give security on your share, but you can't allow them to go and register a lien on a property that is not 100% yours. So number one, not understanding numbers. You have to have a basic understanding of accounting. You have to, when you deliver numbers to your investors, they better be right. Right? I've seen vacancy allowances put into numbers that are actual numbers. Vacancy allowances is a line that you put when you underwrite a deal to see if it's stressed, if there's vacancies, if it will fit. But when I, as an investor, receive a package that says there's a vacancy allowance line, that's like, no, you're just stealing money from me because you're reducing the income. But they had the actual vacancies, and then they had an extra 5% for vacancy allowances. And I'm like, it's not how it works. And I know it was a mistake. They weren't trying to reduce the numbers. They just didn't understand. You have to have a basic understanding of math. If you don't, find yourself a partner or hire a bookkeeper to do this stuff for you. But you need to, when you deliver numbers to your investors, they better be right. Because the second like someone notices these things, it breaches the trust. It really does. And failing to document. I mean, we've talked about this at nauseum at this point. Not doing what you say you're going to do. Under promise, over deliver. And I'm certainly guilty of not doing that because, yeah, anyway. But you have to always do what you say you're going to do, because that's what builds trust. And failure to communicate, you've talked about that, Elizabeth, and owning up to your mistakes. Oh, just own up to your mistakes. Yeah. Right? Like, it builds trust when you say, I messed up. I'm working on it. I will fix it. Be careful. In my view, OPM is not a means to an end. You have to treat it like it is the end. Making money for your investors is the ultimate goal. If you treat it like that, everybody wins. And remember, your reputation is more important than not getting sued. Because as a real estate investor, you're dead in the water if you lose your reputation.
Absolutely. And I think you raised a really good point there, Milena, especially we're seeing it in the market. There are some organizations, there are some coaches out there right now who have all this hype around OPM, and it's, take my program and I'll teach you how to invest in real estate with no money down. Well, when properties have lost 20% of their value in the last year, whose money is it that's gone? Mm-hmm. It's not yours. If you don't have any money in the deal, it's your investors' money. So the question, as Milena just said, how are you going to recover from that? What is the reputational risk? It should be that if you do not steward an investor's money with integrity and with care, you should not be able to continue to invest in real estate. Unfortunately, that's not the way it is. It's really buyer beware, because there's multiple people out in the real estate space who are known to have unethical business practices and yet are still practicing and still able to access money. So it really is incumbent on us to make sure we're doing our due diligence. We're asking around, we're making sure before we lend people money that they have the knowledge, the expertise, and the integrity to take good care of our money. And I have to say, one of the most shocking things I've seen in the last few months was someone using investors' money, using other people's money to cover the minimal costs of doing due diligence. If you can't even cover the costs of doing due diligence, then you need to have a side hustle. You need to have a way of generating some income, because if you decide to walk away from a property and you've done some due diligence and there's a cost associated with it, you have to be able to make your investors whole, because you will not recover from that.
Yep.
So those are my 2 cents. Shaneka, what do you want to throw in there on OPM before we jump into the Q&A box?
No, I think Milena has covered it all. You have to really look at, first, I'll say this. Don't lend or borrow on promissory note. Don't do it. Just don't do it. As much as you can avoid it, avoid it. Because going back to my initial point, it's a piece of paper, right? Someone's giving you a piece of paper promising you to pay back this money. Unless they have a hard asset behind them, if they don't pay that money back on the date specified in that agreement, you're SOL, right? And and always remember, when you get into a lawsuit, you're never going to recover 100 cents on the dollar for what you pay in legal fees, unless Milena drafts your agreement and your agreement says, if we go to court, we're going to recover on a full indemnity basis. But unless that's in your contract, you're never going to recover 100 cents on the dollar. So think about it, right? So if I'm lending you $100,000 on a piece of paper, and I have to sue you to get that $100,000 back, I'm out at least 40 cents on the dollar trying to sue you to get my money back. And once I get that piece of paper, again, if you don't have an asset that you own free and clear that I can sell, and not a 1% interest in, somebody else's JV project, but if you don't own an asset that I can seize or have a job that I can garnish your wage, right, you're out of luck. So really be careful on the promissory note, the loan agreements, and just generally when using other people's money, whether it's the bank or a private individual, just be super careful about doing that.
Mm-hmm.
Perfect. Nicely done. Okay. Thank you, ladies. All right. So let's start at the top here. Is it necessary to incorporate if buying shares in a real estate project? What are the legal liability risks if you're not incorporated? So I'm assuming Maria is talking about if you get into a GP-LP structure or Milena, I know you've done some work with corporations where the corporation owns shares. Can you clarify what Maria might be talking about here?
Right. So, right. Yes. Well, if you're talking GP-LP structures, no, you don't need to be incorporated because there's no liability. The only risk of being an LP in a GP-LP structure is losing your money. The only risk is the money you put in. JV agreements do shoulder liability in a different way. So you are a full-fledged owner carrying liability as a JV partner. Highly recommend being incorporated for that. If you're buying shares in a corporation that owns a project, so we actually closed on a deal like this last year, where we bought a piece of land banking, and it's a corporation that owns the land, and we bought it cash with investor money. They all own a piece of the pie based on the percentage of shares they own. I recommend having a corporation that would then own the money and own the shares in the corporation. And the reason for that is more taxation than anything, because when our project closes and we distribute the money to all the investors really have no say as to when that's going to happen. They have a say in the sense that there is a set trigger event that's going to cause us to do that. But they're not going to be able to say, well, don't give it to me in 2024. I want it in 2025, because for income tax purposes, they can't do that. They're going to get a check and they're going to have capital gains on that money at that time. If you own the shares of the project in a corporation, then the money will move to your corporation tax-free, and then you decide when to distribute it at that point. So that's more of a taxation reason typically. Plus, also way easier to pass that on to your kids if you then redeploy the money into other investments and whatnot. So much easier to pass on in succession planning, to pass on a project to your kids if it's in a corporation.
Perfect. And just for people listening, Milena knows more about taxation than the average bear because Milena is an active investor and also has a top-notch accountant in her back pocket. So Milena will talk more about accounting than most lawyers do.
That's because it's my brother and he's good at explaining things.
Shaneka, Peter would like to talk about prom notes and how secure they are, especially when they're created by potential borrowers.
So to my point earlier, promissory notes are unsecured loans. They are not secured one way or the other unless you have in your promissory note wording that deals with security. And generally speaking, back to Milena's point, you can't secure the note to something, to a physical asset, unless it's registered. And if it's registered, then it becomes a whole different instrument. But you can register a promissory note through the PPSA, so the Personal Property and Securities Act. But to do so, you have to have in the promissory note exactly what you're securing it against. If it's a car, the VIN details, all the details need to be in that note for it to be registered. Without that language, it's an unsecured IOU, is really what it boils down to. And I always say to people who are thinking of giving promissory notes, never give more than you're willing to lose or willing to walk away from. Because this is money that you're giving out and you have no guarantees whatsoever that you're going to get it back.
Yeah, absolutely. And can we just talk for a second, Shaneka, about the recovery process for prom notes? Because there is huge controversy right now in the real estate space. I'm never doing prom notes again. And to clarify, mortgages are different than prom notes, right? Like being registered on title, there's a lot more security. They're not fail safe, but there's a lot more security. There's a lot more recourse available if you're registered on title versus if you and I both sign pieces of paper that says I'm giving you $100,000 and you agree to pay me for it. It doesn't matter if the piece of paper says, you can register later. If there's no equity, there's no equity.
Exactly. And going back to a previous point that I made. So when I said, one of the things that we do in our firm is to do asset searches. So let's say you gave a prom note to someone and you now have to sue them to recover on that prom note. You do an asset search. You say, yep, this person owns a lovely property in the Bridle Path in Toronto. I'm going to lend them this P note because, I can recover on that property. But unless you do a proper asset search and see that beautiful home in the Bridle Path has 3 mortgages on it, with 0 equity pretty much left in it or negative equity, you may not be able to recover on that promissory note, right? So it's really important to do really good due diligence. But going back to your point, Elizabeth, about how you enforce it. So if it's a promissory note that is, the face value of it is $35,000 or less, then if you want to bring a claim to recover on that note, you'd be going to the small claims court. And I like to call it the Wild Wild West court, because the rules are a lot more relaxed than in Superior Court. And generally speaking, the average person can make their way through small claims court without legal representation. But I would always recommend, getting at least a paralegal. But if the amount is over $35,000, then you're going to Superior Court. And so you have to file a claim. The parties exchange what we call pleadings, so the claim and defense. And then it goes through the different stages of a lawsuit. And, we can talk offline about what the different stages are. But suffice it to say that it is not a quick process. The courts in Ontario, particularly in the GTA, are so overworked, so backed up, that it can take years for a claim to be finalized. Even on a simple claim like a promissory note, it's black and white. I lent you this money on this day. You said you're going to pay me back on this day, black and white. To get that claim through the court system, even through an expedited process that we have in our system, could take you 6 months to 18 months. That's just how backed up our court systems are, right? So, and then sometimes clients get mad at their lawyers because they're like, why is this taking so long? But we don't control the court process, right? Because it's just so backed up. So you have to pack patience and you have to pack a lot of risk appetite, I'll call it, when you're going into real estate investing and doing promissory notes.
Is power of sale typically quicker?
Not necessarily. You as the lender, you can take possession of the property, put it on the market, and sell the property, and then recover the amounts that you owe. But in terms of getting a judgment through the court, it's not a faster process, unfortunately, because the systems are so backed up, and because the courts are so backed up, the Supreme Court has actually handed down edicts that say criminal cases have to be dealt with first before civil cases, so we get bumped to the back of the line.
Wowzers. Wow. Okay. Wow. All right. So Brienne said, when should you set up more than one corporation to separate properties versus property management / active income?
Oh, I love this question. So you should always separate active and passive income. And I could go into minor detail about it. I'm not an accountant. Like I said, I've got a good brother who's a good accountant and he explains things well. So I understand maybe more than most, but I'm still not an accountant. But because active income is basically taxed at 12-13%, and passive income is, well, taxed up front at 50%. Then you get the difference back when you pull money out. But because of that, you can play with those really, really well if you separate active and passive income into separate corporations. careful. Property management is a great way of doing that. However, over 30,000, you are charging yourself HST, and that money's lost. So it's really got to be worth it, right? Because that's another 13%. But the other side was when to do multiple. So I have a client who uses a strategy where they do multiple corporations. They use a different corporation pretty much for every investment they do, especially if it's like a certain number of unit and up, and it's not that big of a number. It's like 6 units. So 6 and plus units, they do a new corporation. And I've had other people tell me, well, that seems so expensive to maintain. And it is. It's expensive to set up. It's expensive to maintain. But let me tell you what, in this market, when the mortgage rules are super tightened and investors that do very high volume are having the hardest time refinancing, guess who's having it the easiest? Because it's all in separate corporations. The stabilized properties are with other stabilized properties, and things, he will like move things in another corporation in a heartbeat. Yeah, doesn't matter the cost, because the name of the game is speed when it comes to refinancing. Makes the investors happy, and it allows business to continue. So banks will look so much more favorably at corporations at refinancing a product that is in its own corporation, or that you have a minimal number of projects inside one corporation. Also, do not mix joint venture partnerships where you are not on title with properties that you are on title, because when you go to refinance a property, say you've got 5 properties and 2 JVs in a corporation, right? You go to refinance one of these properties. The bank wants to see your entire portfolio and how it's performing, including appraisals, rent rolls, blah, 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 for the whole portfolio, which is why my client that has multiple corporations is having such an easier time. Because if you have one property inside one corporation, you only need to qualify that one property. So as long as it's stabilized, he's happy, he's getting it refinanced. But if you have multiples, then you'll have to get all 5 qualified. But then the bank's going to look at your financial statements and say, well, you've got other properties in here. You've got other income. What's the source of that other income? Oh, well, that's a JV partnership. Oh, really? Okay. Well, we're going to need appraisals on those properties, and we're going to need mortgage statements on those properties. And then you've got to go to your JV partners and say, we need all this stuff to qualify for a mortgage that has nothing to do with you guys. And we've got to incur this cost for all this stuff and waste all of your time to get all this information. Yeah, don't do it. Keep your JVs and your property ownerships separate.
Absolutely. That's great. And I've actually seen a couple of situations recently where my clients had that. So in a corporation, they owned real estate and they were doing flipping, so active income, and the lender would not extend any financing to them until they separated out the 2 different sources of income. So it's got multiple kind of ways that you can get hung up when you try and sort of mix everything in together. It just doesn't work well at all. Yeah. Okay. Do you recommend provincial or Canadian corporations if you are thinking of investing outside of the province you live in?
I say just go federal, and it's a credibility thing, not really a legal thing, and really makes no difference from a legal standpoint, but from a credibility standpoint, if you're operating outside of just one province, if you're operating in more than one province or outside of your province, just go federal.
Gotcha. Okay. If we shouldn't use a promissory note, then what should we use? Shaneka?
A secured loan, a mortgage. I would say get it secured. Even if you're second or third in line, it's better than being not in line. Because at the end of the day, if that person, let's say, files for bankruptcy or something of that nature, the rules of priority take preference, right? So if you're in first position secured against title, you're going to get paid out, right? The people at the back of the line are the unsecured creditors, like credit cards and promissory notes, that if there's money left over, yeah, maybe you get some pennies on your dollar, but if there isn't, there's nothing left for you. So I'd say go secured always. And if you're inclined to go promissory note, as I said, just think of that money as gone. And then if it comes back, You'll be happy.
And if I can add, there's also different layers of security on a mortgage. So when we go like full blast and we do like a full mortgage with all of the security layers, we're getting title insurance, we're verifying fire insurance, we're doing all these things. I've actually been asked by some lenders to say, can I just do a quick and dirty registration? I don't want anything. I don't want any of that other stuff. I just want to register because it's like a $25,000 loan. How much do you charge to just do a mortgage on the property? Like that would be maybe $500, a lot cheaper. And it won't deter your borrower that's like, well, I don't want to go and spend $3,000, $4,000, $5,000 to register a lien on my property when I'm only borrowing maybe $25,000 from you. This is a way to do it. Another thing is a lawyer can act on both sides of a transaction if it's for $75,000 or less, unless there's like some other reason that like if the hairs in the back of my neck are tingling a little bit, I might say, no, I'm not going to do this one. But most of the time for loans under 75,000, you only need one lawyer to act on both sides. So it doesn't need to be super expensive. Under $1,000, you can get a really decent security without all those extra bells and whistles that you're going to want if you're lending 100, 150,000.
I just learned something new. That was awesome.
Happy to teach you, Elizabeth. It doesn't happen very often anymore.
Oh, thank you for that. Someone has asked when or why we should set up a will for our corporations.
Okay, so I'm going to try to make this really quick because I don't want to get into a whole conversation about estate planning. But so I love this. I love this question. So it's not, often people think it's of it as a corporate will or a will for the corp. It's not. It's a misnomer. So what it is when we're talking about that is we're talking about doing a secondary will. What the law says is that if you have a will, or whether you have a will or not, actually, when you die, you have to pay probate tax on all of the value of all of your assets combined, even if you only need to probate for one asset. So probating is an everyday term to mean obtaining a certificate of appointment of estate trustee, which is a court application. We call it a basket motion. The judge just signs off on it. But we submit an application to the court to issue this certificate that says you are a good and valid estate trustee for this estate, which then gives you authority to act. When you apply for this certificate, you need to pay probate tax on all of the estate. So say you have a house worth $500,000, investments of $300,000, and then you have a corporation with $1 million of net worth in it. Right? So then you are going to have to pay probate tax on 1.8 million, even if you only need to probate the house. What a secondary will does is it creates a second bucket that then your estate trustees can choose which asset they put in what bucket. And their answer is going to be super easy. Anything you need to probate, you put in here, and anything you don't need to probate, you put in here. Your secondary will then hold, in my example, $1.3 million of assets. And your house that's worth $500,000 is going to go in your bucket number 1. You're going to pay probate tax, or your trustees are going to pay, or your estate's going to pay probate tax on $500,000. You're welcome. I just saved you like $15,000 for a $200 document. It's such a no-brainer to get a secondary will done the second you have a corporation. The reason is because corporate shares don't need to be probated. And usually the majority of people's wealth are in corporations when they've used them properly in their lives. That is why when you have a corporation, pretty much the moment you have a corporation that's got an asset in it, it's ideal to do your secondary will. The thing is, when you do a secondary will, you have to redo your primary will at the same time, because otherwise they cancel each other out if they don't say, this is my primary will, at the same time I'm drafting my secondary will. This is my secondary will, at the same time I'm drafting my primary will, and I don't want either of them to cancel each other out, and I want both of them to remain in full force and effect. So you need to have that wording on both. So we need to do the whole, like both wills in order to do the secondary will. So super awesome question. Everybody should have a will and everybody should have powers of attorney. That's a no-brainer. The question is, do you need a secondary will? Do you need secondary powers of attorney? Also really important to determine, and having a lawyer who understands real estate investing, helping you make that decision is really important.
Perfect. Love it. Okay. I'm just looking, there's a number of questions here that really, I think, are more kind of personal scenarios. So if someone has a scenario that they wanted to run by you, are you ladies open to someone reaching out to you afterwards saying, you know, I was on the webinar, can you answer my question? I'm just looking at a couple of them, and they're really, for confidentiality reasons or for, you know, being applicable to the group as a whole, I think it would make more sense for them to reach out individually, if that's okay. So Milena and Shaneka, if you guys can take a look just at the questions in there and message people, let them know.
Can I answer the very first one though? The one that Kim asked?
Yep. Yeah.
So
absolutely.
Kim is asking if a letter of intent is sufficient to hold an agreement. It is not. A letter of intent is not legally binding. Correct me if I'm wrong, Shaneka. Like correct. It's like basic law. Letter of intent is not legally binding. It's just meant as a negotiation tool to then take to your lawyers to draft a proper document, in your example, a JV agreement. So push for that, because your letter of intent's worth nothing.
Agreed.
What would happen if Kim went back? Like if the partner or the borrower went in a different direction and Kim went back, it would fall apart, Shaneka? Like they'd have no grounds to stand on at all?
Sorry, I didn't see the question. I was just answering about the basic legal premise that a letter of intent is not binding, but let me look at the question.
Yeah, it says, is a letter of intent sufficient to hold an agreement to invest in a project until the JV agreement is in place? I've been waiting a while for the document to sign. And
the document being the letter of intent to sign, or the JV agreement?
Sounds like the JV agreement.
Yeah. I would, and maybe this is the risk-averse litigator in me, never hand over money until you have a signed agreement.
But what if someone does hand the money on the basis of a letter of intent, and then they're waiting for the JV agreement for months, and then the other partner refuses to honor what has been agreed to in the letter of intent? What is the recourse of the individual who put up the money? I mean, there's a paper trail that the money was sent. Is it lost?
No, it's not lost. You can always sue to get it back. But again, basic contract law talks about, you know, the parties, are they ad idem? Do they have a meeting of the minds? Are they in agreement as to what the contract or the purported contract talks about? And there's also a law that talks about part performance. So if you don't have an agreement in writing, and segue, all agreements pertaining to land have to be in writing, statute of frauds, right? But if you don't have an agreement in writing dealing with land, there's a principle called part performance. And that means if you've partly performed your end of the agreement, even though you don't have a signed agreement in writing, the court can still look at your part performance or the party's part performance and honor the obligation. So let's say, you know, you put $20,000, $50,000 down in the anticipation of signing an agreement, that never happens, and now you want your $50K back. You can sue to say, look, I gave you this money in good faith with the understanding that we're going to document this agreement. That never happened. So now I'm entitled to my money back because now you've been unjustly enriched by my $50,000, $20,000, whatever that amount is. So yes, you can get the money back, but it's just not through breach of contract situation, but through a different venue.
Wow. Thank you so much. Okay, so Jasmine is a sweetheart here. Sorry, my camera's glitching on me there. Jasmine is a total sweetheart and has said, would we be okay with posting a snapshot of the panel and jotting down some takeaways from the webinar on social media? I would love that. So you guys are always welcome. Grab a screenshot. I would love tag all of us in it. I would love to hear what your key takeaways are, because this is exactly why I host webinars like this and share this amazing info with you. Thank you for asking, Jasmine. That's super sweet of you. For those of you who we haven't had a chance to answer your questions, I'm going to give the ladies a couple of minutes here while I'm wrapping up. Feel free, ladies, jump into the Q&A tab and write your own. And if you think that these people would benefit from connecting with you, feel free to share your info. And I'm going to wrap up the webinar for the evening. Before I do that, Actually, let's do this here. So as always, I'm going to be doing a giveaway for people who attended my webinar live. And today you will have the choice. The lucky winner will have the choice between the Highest and Best Used Playbook by Ryan Carr or the Believe Journal by Brandy Mullen. Shaneka, can you do me a favor? Give me a number between 1 and 66, please. And that attendee number will be sent the book by Mary Beth.
39.
39? Love it. Is that your lucky number?
Today it is.
Somebody else's lucky number too. Awesome. So attendee number 39, whoever you are, Mary Beth will message you probably tomorrow and give you the option to choose between whichever of those books you would prefer to receive. If you are new to my real estate investing community and you have enjoyed tonight's webinar, please go and find me on YouTube, Elizabeth Kelly Consulting. I have about 3 years worth of webinars like this, which are done with the intention of creating high quality, easily accessible, free information from amazing people who I trust from my network. So please go ahead, subscribe to YouTube and join our community. This is where you can reach us. So Milena, of course, with Cardinal Law, Shaneka is with Tailored Litigation, and then you can reach myself as well. All of us are, let's see, we've got email addresses and we've got websites for the lady lawyers. So that's awesome. And if you were not with us last year, I am so excited to announce that we are getting ready for the 2023 Real Estate Resilience Summit. We're going to have 16 speakers, 10 sessions over 2 days, and we are going to be following the same model that we did last year, but we're covering new topics. So our first topic that we're going to focus on is how to preserve the wealth that we currently have in our portfolio. The second topic will be how do we identify new opportunities? And then the third one that we'll be covering will be taking action and what do we do after the summit. So if you would like to stay at the top of your game, if you would like an introduction to new opportunities, new strategies, new information. Right now, your early bird ticket is only $49. You have lifetime access to all the recordings. So I encourage you to please grab your ticket. We are expecting to sell out this year. I'm amazed. We have some fantastic speakers and I'm already blown away with how supportive everyone has been. Thank you so much, Milena and Shaneka, for joining us this evening. It has been an absolute pleasure. You ladies are you guys just know so much. I feel like I could sit for hours. So I'm sure everybody else is going to benefit and enjoy from connecting with you as well. Lots of great info. Oh, someone said, can we have RTO contracts? You can reach out to Milena. Milena has worked very hard to create some fantastic rent-to-own contracts. She is my go-to lawyer for those in Ontario for sure.
Hey, to your own horn too. We work together on those.
Yeah, okay, we work together on those. Thank you to each. Oh, it was such a pleasure. You ladies are so professional. Thank you to all us who joined us on this lovely summer evening. I hope you found it as valuable as I did. And please don't hesitate to reach out to these lovely ladies. You know that they will be right there to help you answer your questions and help you navigate any legal challenges that you're having. And these ladies, they really know their stuff. Thank you, everyone. This is my last webinar until September. So have a fantastic summer and let's stay in touch on social media. Love to see you all there. Thanks, guys. Have a great one.
Bye, everyone.
Bye.